Hello, I'm Ben Barber with the Institute for Southern Studies, and today I'm excited to be speaking with Eileen O'Connor, who serves as senior counsel at the Brennan Center for Justice. And today we'll be discussing, some important issues, specifically the erosion of federal voter protections and the ongoing attacks on democracy ahead of this year's midterm elections. And so, thank you so much for joining us, Eileen. I really appreciate it.
Thanks for having me.
Yeah, and I really just want to, start off with a little bit of context. Over the past 15 years, we've really seen a steady erosion of the Voting Rights Act. Can you really just kind of give us a sense of how these changes have shaped voting rights protections nationwide?
Sure. So just a little bit of background. Most folks probably know the Voting Rights Act was passed in 1965, considered sort of the crown jewel of the civil rights movement. And it had a lot of different parts. And it was also reauthorized maybe 5 times in the ensuing years. So lots of different pieces to it. But the first piece that I think is the most important to talk about is Section 5, which was the pre-clearance provision. And that was really, I think most people consider the genius of the Voting Rights Act, because in the 50s and 60s, when there was work to try to, finally bring the franchise to, mostly Black Americans in the South, um, it was kind of like playing whack-a-mole. So every time a problem was fixed, the jurisdictions would just pop up with new ways to disenfranchise folks. So Section 5, what it did was it froze in place everything in jurisdictions that had a history of discrimination in voting. So most of the Deep South, and then eventually also Arizona, Alaska, some other areas of the country. And that was so powerful because jurisdictions were not allowed to make any changes to their voting practices, procedures, maps, anything until they got them pre-cleared. And so the jurisdictions had to prove that the change they wanted to make was not discriminatory, wasn't going to make voters of color in a worse off position than they were in. So that was incredibly effective and worked wonders. And in 2013, the Supreme Court struck it down. So that provision of the act is essentially no longer functioning. So that was a huge, huge loss in terms of the protections that voters of color have. And we saw immediately right after that decision, North Carolina, Texas, within a day, enacted statewide laws that were then challenged in court as discriminatory, laws that had been waiting to pass until they no longer had the burden of proving that they wouldn't be discriminatory. They wouldn't, badly affect voters of color in their state. So that was one thing that one huge protection that unfortunately has gone away. Then another part of Section 2, and so Section 5, the pre-clearance provision only covered certain parts of the country. There's another part of the Voting Rights Act called Section 2, which covers nationwide. And all it says, it's very simple, is just that minority voters need to have equal opportunity to participate in the political process. And so it basically just means no discrimination in voting nationwide. Unfortunately, that part has been weakened and is currently maybe hanging in the balance. That particular part, Section 2, you can think of like 2 different types of cases. One type that would challenge maps, like methods of election, whether or not it's like a districted map or an at-large map, and others that would challenge, voting, the way people like register and cast a ballot. And so the first type of case there, where challenging the way people are able to vote, register and cast a ballot, that has almost been, there was a Supreme Court case in 2021 that just set a standard to prove that type of case that has so far been impossible to meet. I don't believe there have been any cases successfully brought under that part of the Voting Rights Act since 2021. So that is already weakened. And then I think one of the reasons maybe that we're talking today is there's another case in front of the Supreme Court right now, Louisiana versus Callais, which deals with redistricting. And so that's a different type of, this what we call Section 2 case that can be brought. And it was challenging, that case came from a challenge to the congressional map to it being a discriminatory map. And that is also that is in front of the court right now. And the court may, we don't know, but may also weaken that aspect of the Voting Rights Act. So the court in 2013, when it said no more Section 5, when it got rid of the preclearance provision, essentially said, but that's okay. You still have Section 2. You still have the ability to bring cases under Section 2, which is no comparison to begin with, because Section 2 cases are so hard to bring. They're so costly. They're so resource intensive. They take forever. And the Section 5 process was quick. It was an administrative process, and the burden was on the jurisdiction. And the jurisdiction is the entity that has all the information. So when you're bringing a case against a jurisdiction, you're fighting to get that information in addition to having to prove that something is discriminatory. Whereas under Section 5, the jurisdiction had to take on the burden of proving it. And the jurisdiction had all the information to prove that its proposed change wasn't discriminatory.
Mm.
So in 2013, the court says, we're getting rid of Section 5. We don't need it anymore. The court actually said, there's no doubt there's still discrimination in voting, but you have Section 2, and so you can use that. And then in 2021, they issued this decision in Brnovich, which made it very, very hard to bring one type of Section 2 case. And now there's another case in front of the court that may make it very hard to bring, to challenge basically redistricting maps.
Mm-hmm. And you noted, the case that is currently in front of the Louisiana versus Callais case. Yeah, could you just walk us through a little bit more of the details about that case and just its, potential impact on Democratic representation nationwide, really?
Sure. Yeah, it is very hard to predict what the court might do in the case because it has taken a very strange path. So Louisiana versus Calais is basically a challenge to the remedy that was adopted in a previous case. So already it's like procedurally weird. I'm a lawyer and it's even hard for me to follow it. But essentially, the original case in Louisiana was just a challenge under the Voting Rights Act that the congressional map that was drawn after the 2020 census, so most states have to redraw their maps after each census because they need to have like equal population, generally equal population in districts. So there was a challenge to the map that was drawn in Louisiana for the congressional districts after the 2020 census, brought by Black voters, challenging that it was discriminatory, essentially that there was one district where Black voters could elect a candidate of choice and that the state could have drawn two. And these cases are very complicated to prove all of the different elements, but the plaintiffs there proved all of these different elements. And then the state was permitted to select its own map as the remedy. And the standard in these sorts of cases where the jurisdiction is given sort of like the first opportunity to draw a map that doesn't violate the Voting Rights Act. They drew one that if you looked at it, it looks terrible. But I hate to say that, but it just, they had options of drawing ones that made sense, kept communities of interest together, looked normal. But they chose one, I believe, for political reasons that, looked really insane. And so then after the state tried to adopt that map, a group of white voters challenged it as a racial gerrymander, which is a separate type of case. And that is what has made it to the Supreme Court. So it's a very strange situation. And then so that's why it's sort of very hard to predict what might happen. But it's not hard to predict what can happen to representation if Section 2 is further weakened, if this part of Section 2 that allows voters of color to challenge, a redistricting map or a method of election, if that is weakened or taken away, it would have huge impacts at the local level. I start off with that because the real, overwhelming impact of Section 2 of this ability to challenge um, redistricting maps or the way a school board or county commission or city council is elected has been at the local level.
Mhm.
So, for example, in Alabama in the 80s, there were 92 separate jurisdictions that included school boards, city councils, county commissions that were challenged under Section 2 as having racially discriminatory methods of election. Those were all being elected at large, which just meant that, everybody voted for their top three candidates. And in all of these jurisdictions where white voters were a majority, it was only white candidates, white preferred candidates who won. And voters of color were never able to elect anyone who would represent their interests, anyone who they wanted to. And so there was a sea change in local representation across the South. Alabama is
Mhm.
like a great example just because we have like nice numbers there. But city councils, county commissions, school boards across the South, and in other parts of the country where, like a lot of parts of the country where there are large Native communities as well have benefited from Section 2 in getting representation for voters of color on their local elected bodies. It has, of course, also helped in state legislatures and to a lesser extent in congressional redistricting as well.
Mhm. And, and you mentioned, how Section 2 really became the core protection against uh, federal voter discrimination across the country. So yeah, can you just talk a little bit more about how Section 2 really became the central tool for countering racial discrimination? And how has it really kind of shaped current voting rights litigation in this current moment as well?
Sure. Well, so Section 2 was, all that was left after
Hmm.
um, Section 5 was struck down in 2013. Um, and so we saw for the first time in the last decade, the use of Section 2 to challenge, practices and procedures related to voting that would have been caught by Section 5 previously. Um, So the use of Section 2 to challenge things like voter ID or rules about registration or rules about absentee balloting, those are recent. Those have really only been brought to a much of a large scale within the last 15 years or so because Section 5 used to
Hmm.
cover so much of that. But excuse me, when I explained that Section 2 has these two different types of cases, the vote dilution is what the cases are called that are challenging methods of election, like if it's an at large or if it's a map. Um, those cases had a huge impact in the 80s. Those were not that type of change wasn't necessarily Section 5 wasn't necessarily as useful for that because it was harder you couldn't really use Section 5 to have a jurisdiction change something. It was just Section 5 froze things in place.
Yes.
Um, but the vote dilution part of Section 2, that ability to challenge methods of election to try to get um, situations where voters of color can elect candidates of choice had a just massive impact over the 80s, 90s, 2000s, and cases are still being brought under that. Louisiana, I believe Texas's statewide maps have been challenged practically every redistricting cycle, usually where the plaintiffs wind up winning, though it does take a long time.
Hmm. And if the Section 2 protections were weakened even further, what other legal tools or avenues could be used to kind of challenge racial discrimination in voting through the judicial process?
Yeah. There are other ways it becomes more challenging.
Hmm.
We do still have the 14th and 15th Amendment. And so there are still prohibitions on intentional discrimination in any aspect of voting. So including in the drawing of maps. Those are much harder to prove because proving intent means you have to prove that whoever was drawing the map, intended for it to disadvantage um, Black voters or Latino voters. You don't have to prove that they're racist or anything like that, but you have to prove that it was the intent that they were drawing it to disadvantage voters of color. So you have that. There are some states that have state voting rights acts.
Hmm.
I don't believe any states in the South have voting rights acts at the moment, have state voting rights acts at the moment. But that's another avenue. I know there are folks who are, working to try to get those passed in some of the states in the South. So that may be an option. And there are other pro rules that some states have about how redistricting should be done that can be used to make maps more fair. Though specifically, it is, those rules may be things like a whole county provision where you're not supposed to split counties, um, rules about like keeping communities of interest together. Folks can try to use those as well. Those haven't been tested as much because we have had the Voting Rights Act and it has been a very effective tool.
Hmm.
It's very hard to bring Voting Rights Act cases and to actually win them, but it has been an effective tool to challenge discriminatory maps and to try to get them fixed so that voters of color can actually, participate in the process.
Hmm. And like on top of all of this, like on top of the legal cases we've seen in the courts, we've also seen just this increased federal interference in state elections, really starting, I guess, last year. Um, from efforts around redistricting to the Department of Justice trying to obtain state voter data. So I guess, like, with all of that going on, how concerned should we be that these actions could, really threaten voter privacy and the integrity of the midterm elections?
So I think people should be very aware of what's going on.
Hmm.
Um, at the moment, though, the pushback against these federal efforts has been quite effective.
Hmm.
For example, in the states that have been sued by the Department of Justice, you mentioned efforts to gather data. Um, Folks may or may not realize, but the Department of Justice has asked almost every state in the nation to hand over their voter files, including driver's license number, social security number, which is an unprecedented act by the Department of Justice. This is not what they do. They don't sweep up voter rolls and go through them and analyze them themselves. They don't have the authority to do that. They don't have the expertise to do that. And they've sued 24 states plus the District of Columbia for refusing to turn over these data. And so far, three of those cases have already been dismissed, meaning that judges have said the Department of Justice doesn't have the authority to demand these, and that the states don't have to turn over those voter rolls. So that has been very effective. The Department of Justice is continuing on that, and that is certainly, we think, part of a broader campaign to lay the groundwork to try to interfere in the elections. But several several things. States are pushing back against it. The courts are also not going along with it. And then also just a reminder that, our elections are run at the local level and there are benefits to that. There are benefits to a very dispersed set of election little, different elections going on at the same time, basically sort of like 10,000 different elections going on at the same time, is that it's very hard to interfere everywhere. And also, elections are run by professionals. They're run by people who are Democrats and Republicans who are just interested in having safe and secure elections. And that is so far what we have always had. And there's not a reason to believe that we won't continue to have those, but people should still be, I would encourage people, to still pay attention to what is going on. If you live in a state where your Secretary of State has handed over the voter files, which is 10 states so far, at least, call up your elected official, ask what's going on, make sure that they're going to not take the Department of Justice's word on who should be removed, because that's one of the things that the department is attempting to do, is to tell states, you have to remove these voters because we think they shouldn't be on your rolls, which is just, it's not something they've ever done before, and it's not something they have the authority to do. Um, but then also, as always, make sure you're registered and that you have a plan to vote.
Hmm. And, and you mentioned, kind of this, kind of the broader campaign to kind of really disrupt elections. And this is not new. There's been a really a decade long strategy that we have seen. Um, but this week, I believe, Republican lawmakers in the House and Senate are pushing the SAVE Act.
Hmm.
Um, yeah, and can you just kind of explain how this bill and really other voter suppression measures we see kind of really fit into this broader, specifically federal effort to influence or disrupt free and fair elections?
Hmm. Yeah, so that's sort of a different track that, again, people should also be paying attention to. So what we were just discussing is coming from the administration, so
Hmm.
from the executive branch, which does not have the authority to make rules about elections or anything like that. The Department of Justice has the authority to enforce to enforce laws that Congress passes, and Congress has some authority to pass laws regulating elections. Um, the SAVE Act, or the various versions of it that have been introduced, are all, as you said, like, they're voter suppression laws. They would have terrible results. They would disenfranchise millions of Americans based on lack of, the identification that they're requiring, which is essentially a passport or a birth certificate, for some of these versions. And so I think there's very strong pushback against those laws. They tried to um, introduce one, they did introduce one, and I believe the House maybe passed it a year ago. And there was a huge pushback because it was so terrible and would have such negative consequences for our elections. And I think we're seeing a very similar pushback now I think there may be 3 different versions floating around, but I think we're seeing a similar pushback now, because people want people wanna be able to participate in their elections, and this bill would, make that, you know, so much harder and seemingly impossible for a large number of Americans.
Hmm. And, and really, just one final question, really, and you really kind of already touched on it a little bit, but with the midterms already quickly approaching and, amid attacks on voting rights and really the erosion of democratic norms nationwide, what legal strategies or other insights would you offer to people working to protect democracy, not only for this year, but really for beyond as well?
Mhm. So I think it's much the same um, advice that I have given, for years now, which is, on the individual level, register to vote, check your registration, um, make sure your friends and your family and everybody does the same, and then, be sure to show up to vote. Here, also figuring out, what are the options that your state offers in terms of early voting, voting by mail, other absentee voting in person, really getting engaged on that level. I also encourage folks to consider, like, running for local office. Those local races, they are so important, and I don't think people ever pay enough attention to them. But for example, at the county level, those county elections often determine who is running your elections. And so you want to get engaged there to make sure that the folks who are going to be running your elections are, professional, they're acting in nonpartisan manner, and just, you know, focused on safe and secure elections that are accessible to all. Then I think it's also important to, on the national level, you already mentioned the things to pay attention to, you know, call your representatives, tell them the SAVE Act or whatever the different versions of it are terrible, and they need to be, like, vocally opposed to them and vote against them. And similarly, to calling your representatives and saying, I'm concerned about what the Department of Justice is trying to do with their interference, and I want to know what you're doing to push back against that interference.
Thank you so much. I think this was a good place to stop. I really appreciate it, Eileen.
Sure. Happy
I
to be
think
here.